Good morning, good afternoon, good evening, whatever time of day you're watching this. I'm not entirely sure when I'm going to publish this video, purely because there's a bit of a legal issue with it. That being, I'm in court tomorrow. It's the first time, as an expert witness, I've actually got to go to court to give my expert evidence. So what I thought I'd do, I've not seen anything like this online. Is I'm just going to keep a little bit of a video diary as to what I'm going through, what my thoughts are, etc., etc., from now until the claim is settled. So a little bit of background on the case without giving too much away, of course. It's a tenanted property and the tenant has made a claim against the landlord for nuisance. So slightly different to a civil claim, this is actually a criminal claim. So the tenant is the prosecutor and the landlord is the defendant. So what are they complaining about? Well, the complaint of nuisance is for damp and mould. The solicitors acting for them is one of these big no-win, no-fee type kind of firms, and they've appointed their own in-house expert. I'm not entirely sure of the morals of that, whether it's legal. I'm sure it's legal because that expert, ultimately his duty is to the court. It just, sometimes these things just don't kind of sit right. Anyway, that's not really for me to argue. The point is they've appointed their own expert who's had a look around the property and has highlighted one or two fairly minor areas of mildew as being nuisance and hazardous to health. I don't particularly agree with that, and he's argued with me that I've failed to apply the appropriate test for hazardous to health. My argument is he's failed to apply the same test by his own logic because he hasn't actually defined what those hazards are in any detail other than there's a bit of mould, how those issues have come to be and what specifically the hazard to health is. So being criminal, it's for the prosecutor to prove rather than for the claimant, for the defendant to prove not, if you like. So I visited a month or so ago, looked around the property, did all my usual psychrometric readings throughout the property, condensation profiling, thermal imaging, and concluded that it's a condensation issue. It's happening in 3 different areas of the property, bit of mildew growth, nothing major, no particularly high readings, but yeah, condensation. But the building is solid brick property. It's best part of pushing 100 years old or so now. It's been like it for a long time. So we're kind of head to head at the moment as to whether it's the tenant's issue or the landlord's issue. Now he is saying it's 100% the landlord's issue, and he's actually said in his report, I can confirm this has nothing to do with the tenant, it's all the landlord, but then he hasn't said what or why. I'm saying, yeah, there are 1 or 2 bits and pieces, and the landlord's immediately gone and repaired those. But fundamentally, a property will not produce moisture itself. The conditions of a property can allow condensation to occur, but a property won't produce moisture. The only things that can produce moisture are inhabitants. Living, breathing, cooking, bathing, flushing the loo, washing your hands, drying your hair, drying your clothes indoors, all moisture producing issues. And this moisture is then going to condense on colder walls of the property and cause condensation. What then can aggravate that is if we have low building temperatures, so the dew point is then effectively increased, and then we'll get surfaces of walls below the dew point, and then condensation on those surfaces will occur, which is exactly what's happened. And this chap has put in his report lots of photos of an MMS2 protimeter showing relative humidity and temperatures inside the property. That to me is not evidence, that's part of a story. So what he's saying is, look, really high relative humidity, 68%. Okay, well, what was the specific humidity? And what, more importantly, was the dew point? So if you've got dew points below those temperatures, bear in mind the room temperatures in some cases are into 14 degrees in the middle of winter in a domestic property. So you've got cold air, high humidity, so high relative humidity is going to be high because it's a relativity is how much moisture vapour that air can hold at that temperature. Increase the temperature, relative humidity comes down. None of that's mentioned in the report, which is hardly surprising. Anyway, long story short, I'm finding myself waffling a bit now. So I'm in court tomorrow for the first time. So I did my training many years ago. So I have been cross-examined in court conditions, but not for real. So how am I feeling? A little bit nervous. I think most people would be. If you're not nervous, I don't know what's going on. But there's got to be a first time for everything. I took on expert instructions knowing that at some point I would be examined and cross-examined in court on the evidence I'm providing, my thoughts, my opinions, how I've reached those, what my qualifications are, have I considered other stuff? Yes, I have, and blah, blah, blah. So I spent this afternoon rereading the entire bundle. That is the claim, his report, my report. He went back and visited the property, produced another report, didn't give me that. The experts then have a list of stuff that you agree or disagree on. So it's a joint statement. So we had three issues basically of the damp and the mould in three different rooms, and they've redecorated until those issues have gone away. But they're still pursuing one issue in the room they didn't decorate. So we've then got a joint statement that we need to that we've done and issued all that as well. So I've read through all that, and this evening I'm going to read through all again, particularly my report, because it's my report. I need to be able to know inside out. I do, of course, I've written it, but I just need to check it again. So I've got an early start tomorrow. I'm due in a court, so I'm not going to say which one, tomorrow, and I'll do another video in the morning on my way to let you know how I'm feeling tomorrow, because I might be even more nervous then. I'll speak to you in the morning. Thank you.
Okay, so I've arrived at the courts. As I said before in that intro that I did yesterday evening, this is my first court experience as an expert witness. I have no issues with what I'm saying at all. I know what I'm doing, but obviously it's a new environment, so I feel a little bit nervous, but we'll see how it goes, and I'll catch up with you afterwards. Okay, well, what a day. My first time in court. Where's my light gone? There we go. Sorry. So my first time in court as an expert. Got there at 9:30. So I'm trying to do this really for the benefit of anyone who's never been. Got there at 9:30. Then through the scanner, bag checked, all that kind of thing. Met with my appointing, the defendant who I'm representing, and counsel at about just after 9:30. Sat in a little side room office thing till 12 o'clock, nothing to do. The two barristers were arguing a couple of points of law, and that took from 10 till 12. Then we're all invited in, and they had another couple of points of law to argue, which took another 2 hours. So interesting in some respects, boring in others. So we was then set out for an hour and a half, back in at 3:30, because the judge had some bits and pieces to sort out. So then the trial started proper. So the claimant gave her evidence, cross-examination, and then re-examined. And by which time I'm starting to, get a bit more nervous, because I think, okay, my time's coming. And then by now we're about 5 o'clock, something like that, pushing 5 o'clock. And the claimant's expert surveyor, kind of surveyor, he then gave his evidence. That took an hour and a half almost, so it didn't even get to cross-examine time. So just after 6 o'clock, the judge basically called an end to it. So we're going to meet back in end of January. So I'll see you on this video in end of January. Say have a happy Christmas, but by the time this is published, it's going to be February. Anyway, interesting day. But the claimant's surveyor has he's tried to diss me as much as he can, discredit my report and stuff. But the interesting thing is, the more he's done it, the more he's proven that his building pathology skills really are not up to scratch. And the defendant kept looking around at me with the most shocked, worried look on her face, and I'm just like that. But I'm trying inside not to smile, because I think this could not go any better. Basically got a guy sticking a pin probe in a wall and diagnosing all sorts of damp issues and not considering the basic facts right in front of him. Anyway, so afterwards I said to the barrister, I said, seriously, that could not have gone better. So whereas this morning I was really nervous, I'm now really looking forward to getting back in January. So we'll see how it goes. Nothing's won yet. Can't count your chickens before they're hatched and all that. But yeah, I'll still see you in January. Good evening. Let's take those glasses off so I can see the screen rather than seeing my glare. So I am back in court tomorrow. This follows on from my other little 3 snippets. The one I did in here, best part of 6 weeks ago now, I think it was. It was early December, something like that. I can't honestly remember. So the purpose of me doing this is the first time I'm giving expert evidence in court. No matter what we do, no matter how much advice we give, we've always learned or done something for the first time once. So I thought, what a great opportunity to get my first time on court, the lead up to it, obviously not actually appearing in court, but the lead up to it on video. Just hopefully if anyone else can see or gain something from it, absolutely brilliant. I'd love that, and that's my absolute intention. So my other 3 videos, I did one sat here, like say 6 weeks ago. I did one when I arrived at court, and then I did one when I got back on my driveway at like 8 o'clock at night in absolute pitch black. So I do apologise for the colour quality of that one. Tomorrow, I'm hoping that I'm going to be back in daylight. Reason being, the 2 barristers spent pretty much half the day from like 10 o'clock till midday or so, arguing a point of law. They then spent from after lunch, so about 12:30, 1ish, to I think it's about 3 o'clock, arguing another point of law. So all that took most of the day up, and so it didn't actually get going until 3 o'clock. So tomorrow, first things first, I think, is the surveyor, the expert for the prosecution, if you like, because it's a criminal case. The expert for them will be cross-examined because he's given his evidence, so he'll be cross-examined, and then he'll be re-examined on a few points. Then it'll probably be either myself, or if the judge wants the 2 experts side by side, so it's all fresh in their mind, or it will be the defendant, and then I think the barrister wants to recall the the claimant, and then it'll be me. So but I really can't see that taking all day, maybe up till 12, 1 o'clock or so. It's relatively straightforward. So I'm not really giving it all that much thought over the last month or two, but the 31st of January has rolled around quite quick. So now, yeah, feeling a little bit nervous again. I am confident in what I'm saying. And it's an interesting one because we, as professionals, we do what we do every day. We know what we're doing. Hopefully, most of us are pretty good at what we're doing. And I include loads of other surveyors in that. You know, there's loads that are probably damn sight better than me. We know what we're doing, but when someone that's very clever asks certain questions that you've got to be able to answer like that, and in such a succinct way that a lay judge can understand what you're saying, then yeah, it makes you feel a bit nervous. So stick with it. Thanks for getting this far. I shall do another one on my way in the morning because I'll probably stop at the services for the usual wee and a coffee. And then if I remember, one on the outside the court when I get there, if that's applicable, and then one when I get back. So I shall catch up with you in the morning. Okay, we're now into the following day. So I've just arrived at court. I'm well early, about 45 minutes early, which is always a good thing. Much rather sit around and wait than be rushing and late. So what I'm going to do is I'm going to go through my report again, go through the other side's report again, see if there's anything I've missed. Hopefully not. And yeah, and I'll get going in half hour, 45 minutes or so. Feeling a bit nervous, as you may expect, being your first time, but let's see how it goes. Okay, good afternoon. So back at the services now, having all done for the day. My client won. I'm not going to be able to keep the smile off my face, but I have learnt so much today. Yes, as I said before this morning, nervous going in. So it starts at about 10 o'clock or so. And the barristers, our barrister, if you like, the defendant's barrister, put in a submission to basically have it thrown out because the tenant had moved out of the property a week ago. But because it's not a housing disrepair claim, it was a claim under Section 79 of the Environment Protection Act for a nuisance, damp and mould nuisance. the judge decided no, that it could actually carry on because she was a tenant when the claim was started back, I think it was January last year or something like that. We got involved in August. So the last time the expert for the claimant was examined in chief, and today he was then cross-examined, and that took about 2.5 hours. And it's amazing how someone who's done apparently hundreds can be ripped apart, which makes me think, oh my god, it's going to be me one day. But the chap just didn't understand dew points, absolute humidity, condensation, stuff like that. He kept going on that the issue, the structural issue, was the damp. The damp's the structural issue. Well, no, the damp's a symptom, not the actual cause. And we stopped for lunch, and after lunch another submission was made by the defendant's barrister, basically saying that this evidence just proves that this is nothing to do with the defendant, who's the landlord. It's living conditions, or living lifestyle, if you like, of the tenant. She was drying clothes indoors, she had a baby, she wasn't heating the property sufficiently, she wasn't using ventilation that's provided, and all these issues the claimant's expert just completely ignored. He ignored the fact that the rooms were down at 14-15 degrees. He said I was wrong because I referenced Public Health England saying that the comfort range was 18 degrees plus. He said it was 16 degrees. I found the document immediately which proved it was 18 degrees. But even by saying that or getting drawn into the conversation, he's acknowledging the fact that he's not made any reference of that in his report. So he's almost discredited himself in some degree. I really was looking forward to having a go, because I might have mentioned on the one where I sat here in the dark at home in December last year that I was really looking forward to having a go, because the guy just not said so much, and it just demonstrated his lack of building pathology knowledge. Now, I don't want to diss anyone, but he's not a surveyor. He's a environmental health officer. No, not called an officer because he doesn't work for a local authority. Environmental health consultant. So probably when it comes to nuisance, when it comes to noise abatement, stuff like that, then yeah, he's going to know loads more than me. But I wouldn't get involved in expert instruction on that. This was simple. This was damp and mould, which immediately I saw the property, I had a pretty good idea it was condensation, and then my report just backed up and proved that. He didn't, and he tried to prove it was due to the landlord, and you're going to get found out. If you like the idea of expert stuff, or just courts in general, because it does fascinate me. When I was doing my degree years ago, I was awful at law. I literally scraped a pass and I had no interest in it whatsoever. But as the years go on, I'm more and more interested in it. I have thought recently about doing a law conversion course just for fun, but we've got so much on the go, I just haven't got time for that. Anyway, I'm going to carry on as I am. I hope you get something out of this. So I didn't get a chance to do my oral evidence or be cross-examined, so that's going to have to wait till another day. But I've got another court case booked in May, so we'll see then. Anyway, once again, thank you for getting this far. It means so much to me when people subscribe and give me comments, constructive comments. Don't give me any bad ones, fortunately. So yeah, thank you very much, and I shall see you on the next one. Not quite over and done with yet. Having sat on this for a few days before I got around to editing the video, not that I do much editing, as you probably see, I thought, do you know what, I'll add a little epilogue because it's not quite as it seems, and having had a chance to reflect, I can add a fair bit more information to the end of this, which is not necessarily building survey related, but it is useful, I think, regardless. So first things first, my client didn't win. The case was actually thrown out. I said they won because for them it felt like a win. It's been plaguing them for quite some time, but because of the incompetency of the prosecution side and a prosecution's expert witness who was demolished, I think is probably fair to say. Our barrister, or the defence's barrister, stood up and did a speech to have it, a submission he called it, and we was asked to leave the court, and the judge basically said, look, there's no case to answer here. So a few reflective thoughts. Now, if you've listened to or read The Secret Barrister, you'll be aware of something called the innocence tax. And that's effectively how my clients feel right now on this job, on this claim, should I say. So they've rented a 2-bedroom ground floor flat to a young lady on her own with a couple of kids. And through no fault of their own, because there was no case to answer, the tenant decided to bring a claim against my client by one of these no-win, no-fee solicitors. I'm not going to say their name, but there are a fair few of them about. And if you perhaps put housing disrepair into your search engine, you'll get loads of them come up on your Facebook feed. So she's made a claim against my client. That's been thrown out. My client's now got a bill just shy of £30,000 to defend that claim against her. The tenant, so who was because it was a criminal claim under the Environmental Protection Act rather than a civil claim. She was a prosecutor. Her claim would probably cost a similar amount. So you're looking at thick end of £60,000 in fees for the lawyers, the barristers, and everyone else and the experts. And she didn't win. So not only did she not win, she was under one of these no-win, no-fee agreements, which is fine, potentially from her side. But my client suffered nearly £30,000 in losses because of a spurious claim against her. So she's now going for an award of costs against this young lady. Can she afford it or not? I don't know. She may have other properties and she may rent that. I know a few people that rent for their daily where they live, but they also own other properties that they rent out. So she may well be able to afford it, but I suspect not. So I'm not sure how that's going to affect that young lady's life for owing this amount of money to someone else. But she's been swallowed up by this no-win, no-fee idea that we can get you this, we can get you that, we can get you compensation, it won't cost you a penny. But now they've lost. That's slightly different. So let's just look at why they lost, or why the case was thrown out, should I say. Because I think this is perhaps the most fundamental part of it. The no-win, no-fee solicitors, they're based up north somewhere, as a lot of them are. I don't know why, but a lot of them around Manchester and Burnley way. I've been up there, and they're the most nicest people in the world. But a lot of the firms up there, a lot of the no-win, no-fee solicitors seem to be in that kind of area. In a similar case to a lot of the spray foam rogues that we've come across have been down in kind of Poole and Bournemouth area. So I don't know why. It's by the by. Anyway, so they've appointed an expert who's gone out and looked at it, and he's kind of driven it, if you like, to say the property is prejudicial to health. There is damp and there is mould. And one of the issues is a broken window. And one of the other issues is damp in the bay window. Now, he's not stated what the cause of the damp in the bay window was, and this is the substantial issue that came across in court. Why not the broken window? Because as soon as I reported to my client that there was a broken window, it didn't close by about an inch. They got the wheels in motion, they got that replaced straight away. But the expert surveyor for the prosecutor, the claimant, was adamant that the damp in the bay was a structural issue. What I think he meant was it's affecting the structure of the property. But as expert for the defendant, it's not for me to guide that expert who's acting for the claimant. So in court, as someone who's not a chartered surveyor or not a qualified surveyor to any degree, he's an environmental health consultant. He kept saying that the damp is a structural issue. Damp is a structural issue, and wouldn't advise on what the structural issue was that was causing the damp. Now that was pushed and pushed and pushed by the counsel for the defence, as you would probably understand. And once he knows that there's a little chink in the armour, he's going to push it and push it and push it until he gets his own way, or until the guy fails, which is essentially what happened here. And as I said to the barrister when we was having a cup of tea, the damp isn't the issue. The damp is the symptom of an issue. I'll give you an example. A structural crack leads to potentially penetrating damp. High ground levels may lead to penetrating damp. Snots in the cavity may lead to penetrating damp. An overflowing gutter may lead to penetrating damp. Not using ventilation that's provided may lead to condensation damp. Over occupancy, drying clothes indoors, using an unvented tumble dryer may lead to condensation damp. And that is exactly where we was at with this job. It was condensation damp. Now, what also didn't help the prosecutor's side was the surveyor was adamant that you can't get a high damp reading of 700 or 800 on a scan method of a damp meter and it be condensation. So look at these photos. You know, these photos are very high damp meter readings. And in this one here, we can see the carbide reading of, what's that, 1.1 on a really, really high damp meter reading and very low psychrometrics. This is condensation damp. So the dampness is only on the surface of the wall, probably soaking a bit into the plaster, but it's not indicative of a structural issue. And because he decided to comment on it being a structural issue, what does our barrister ask? What are his structural surveying qualifications? Are you a structural engineer? No. Are you a chartered building surveyor? No. So you're not qualified to comment on this. So while sat in the public gallery, effectively, I can see what this guy's trying to say. It's not for me to argue his cause because he was fundamentally wrong, but he just got absolutely tied up in knots. So anyway, that was my very first experience twice of going to the court twice and not getting to speak at all, or not getting to speak actually in the witness box. It will come again. I've got another one booked in May, so we'll see how that one goes. So this really is the end of the video. So once again, thank you for getting this far. If you do like what we're doing, please like and subscribe, and I shall see you on the next one. Thank you.